And while I'm here tonight to talk about conscience rights specifically, I think it's important, given what I've heard here so far tonight, to mention that we believe that Bill C14 gets a number of things right. It was in the context of noting the need for legislative reform to allow for medical assistance in dying that the court discussed and reiterated the conscience and religious rights of medical practitioners, stating that nothing in the Declaration of Invalidity which we propose to issue would compel physicians to provide assistance in dying. That's at paragraph 132. Instead, the court underlined that the charter rights of patients and physicians will need to be reconciled. And it was within the rubric of reconciling those rights that the court in Carter suggested statutory balancing, right? Statutory address. And unfortunately, Bill C14 fails to do that. It's our continued recommendation that in order to comply with Carter, that Bill C14 should codify the protections for the conscience rights of physicians, nurses, pharmacists, and other healthcare workers, as well as healthcare organizations and institutions, to refuse to participate in and refuse to refer for MAID. The applicants in Carter neither sought nor received a charter right to compel doctors or healthcare workers to provide or refer for MAID. Despite that fact, the colleges of physicians as well as nurses associations have instituted requirements that their respective members participate in MAID in disregard of conscience rights on pain of professional sanction and reprisal in some cases. This is Parliament's opportunity to bring uniformity and clarity to the issues of conscience rights and MAID for that reason. I have two pragmatic reasons, in addition to the reasons that were set forward before the subcommittee. First of all, tens of thousands of Canadians trust and rely daily on medical practitioners to perform their duties in an ethical and conscientious manner in the provision of service. The provincial colleges of physicians have ethical requirements for doctors, and they expect physicians to be governed by a strong sense of moral and ethical responsibility. We say that this committee has to consider the ramifications of overriding a physician's conscience in one aspect of service and then expecting that same physician to act in a conscientious or ethical manner in all of these other service requirements. We also say that it's important for Parliament to recognize that what Carter was talking about was a balancing of rights. There is a right to die recognized in Carter, but there's also rights for medical practitioners. And it's important to not lose sight of the forest for the trees. The people who, under this current Bill C14, will be implementing MAID are people who are going to wake up tomorrow morning and look themselves in the eye and have to continue on with their daily business and know that they perform their duties in an ethical and conscientious manner. And the people who have availed themselves of MAID will be gone, but the medical practitioners will still be here. And in my respectful submission, I don't mean to be trite, but isn't a proper balancing looking at somebody's life who is on the verge of expiring, weighed against the decades of medical practitioners who still on a day-to-day basis must act in a conscientious and ethical manner? Is it not disproportionate to focus solely or almost exclusively on the rights of patients as opposed to those who are tasked with implementing MAID? We say it is. We say that a proper balancing would never oblige an individual to participate in MAID. And there's been lots of discussions about whether or not it's legal or constitutional to include a protection in Bill C14 for conscience rights. We say it is. First of all, it is clear that right now, Bill C14 is dictating how MAID can be implemented and who can implement it. And so it is making regulations, it is making laws, or it purports to make laws with respect to how MAID is to be carried out in the province. And if the province is the sole entity that can make laws with respect to MAID, then this legislation would be offside. It's clear that that's not the case. We say that it's apparent that conscience rights can be protected. And I direct your attention to the circumstances this is just one example out of a number that we've thought of, but of course the general rule with respect to culpable homicide is that there's no killing. Sort of similar to the general rule that if you are a Canadian individual or an organization, you have to pay taxes, because taxes is federal taxes are the purview of Parliament. But charities are controlled by the provinces, and under Section 92 of the Constitution Act 1867. And yet charitable organizations have to make application to the federal government to both obtain charitable status, right, and continue it. And the reason that's the case is because otherwise they would not be allowed to do what they are allowed to do, which is accept tax-exempt donations. And in summation, I'll say that there are other analogous circumstances, such as in the Civil Marriage Act, where there are enumerated protections for conscience rights, and we say it would be a mistake not to codify the same in this legislation. Thank you.
You stated in your testimony that it was your opinion that Parliament has flexibility constitutionally to enact conscience rights protections, and you cited some examples where Parliament has enacted laws or regulations in other contexts, but perhaps you could elaborate a little bit under what powers Parliament does have to enact conscience rights protections.
We say that this is an unusual situation because what's happening here, it's important not to miss that what's happening here is the carving out of an exemption for culpable homicide. And because Parliament is carving out that exemption, we say that that Parliament can set the parameters with respect to who is instituting MAID, how it's being instituted, and we say that the 15-day waiting period, for example, would be constitutional because that is within the boundary of that exemption that's being carved out. We say that it doesn't trench on the provincial powers. We say it's necessarily incidental for the exemption that's being carved out, and we know that the Supreme Court of Canada has given that mandate to Parliament. So the expectation when I read Carter is that the court expects Bill C14 to balance those rights, and that's what's conspicuously missing. And we say that there's nothing wrong with putting that protection in the criminal code power, under the criminal code power, under the Constitution, under Section 91 of the 1867 Constitution Act.
Right. And also on the area of health care, and I agree with you, Parliament would have ample room in terms of criminal law power to legislate in this area, but also the Supreme Court at paragraph 53 in Carter specifically said that in the area of health care that it is an area of concurrent jurisdiction in which both federal government and provincial governments can legislate. So I think even allows greater flexibility in which to legislate. But certainly Parliament does have the ability to legislate, but I guess then the question becomes how far does Parliament have in the way of legislating? A similar question was posed to a witness earlier this evening, Professor Plotier, and she seemed to suggest that Parliament could enact conscience protection legislation along the lines, for example, of Section 3.1 of the Civil Marriage Act, but she then seemed to say that that would be about all that Parliament could do in the way of conscience protection legislation. So could you perhaps elaborate on how far Parliament can go to protect conscience rights?
Without a reference to the Supreme Court of Canada, it's impossible to say entirely 100% for sure. I can't say, and I feel like I would be delving into the realm of speculation to say. Suffice to say, I think that this bill can enact protections with respect to conscience rights. I think that under both the criminal power and the health power, that Parliament has that jurisdiction. And I also think that the Supreme Court of Canada has sort of tipped its hand that it intends to be deferential with respect to this legislation. So that's my response.
How long do I?
You have two more minutes.
Oh, 2 more minutes. Well, and I would simply note that if Parliament did not act, it would be left to the provinces, and that would create a patchwork of inconsistencies. Indeed, it could leave a situation where where there would be no conscience protections anywhere, or at least in certain provinces, and that would make Canada unique to every other jurisdiction that has some form of physician-assisted dying. In every other jurisdiction, there are some form of conscience protections enacted. Canada would have a vacuum in that regard, and that obviously would be very concerning. I don't know if you have anything further to elaborate, Mr. Cameron.
I would say this, that Justice Dixon in Edwards' books at paragraph 143 counseled the avoidance of inquiries into people's religious beliefs. And from our perspective, this doesn't have to be made to be about religious beliefs. There are long-standing, thousands of year-old beliefs with respect to the killing of your patient that were originally enshrined in the Hippocratic Oath. The Nightingale Pledge, which is the nurse's version of the Hippocratic Oath. They've been in existence for centuries in various forms, and many, many physicians today, you heard the statistic, 70% don't want any part of this, right? And you don't erase centuries of conscience protections that are ingrained in the medical profession with the slash of a pen. They're there, and whether they're ethical or they're conscience or they're religious based, or it's just we feel uncomfortable about it, we don't want to participate, they have the right not to do that under the Charter. That's our position.
Mr. Cameron, I'd like to turn to you. Is there, leaving aside medical assistance in dying, is there another medical procedure out there in which a physician has been coerced against their will or against their own conscious beliefs that you're aware of?
I think that the answer to your question lies in the history of the medical profession.
Let's not go back to the history of the medical profession. Today in Canada, let's look at what can you answer it based on today in Canada, what other medical procedures you're concerned about, that it would be a concern where physicians are struggling with conscience?
Well, I don't know of an analogous situation where the consequence of the act of a physician is the intended death of the patient. So there's nothing analogous that I can think of. Physicians and nurses were trained and raised up to care for patients and provide health care, and I share the concern that another panelist mentioned tonight, that killing a patient isn't consistent with the idea of health care.
But again, Mr. Cameron, you're venturing off in terms of the specific individual. There's no other case that you can point to, I guess is the simple answer, that there is a concern with conscience rights in the medical profession. And my next question goes to the colleges of physicians across the country are self-regulating in terms of ethics, as are the bars of the various provinces. Why are you advocating for regulating the professions, which clearly isn't within the jurisdiction of the federal government?
I'm not advocating for regulating professions. But I would note that every single month there are lawyers who are disbarred for malpractice and for improprieties, and it's clear from the study that was released today that whether it's intentional or accidental, the medical profession makes a lot of mistakes and kills a lot of the patients that it's supposed to be helping.
The medical profession, like the legal profession, gets to determine what is unethical.
Only so far, sir. Parliament decides what's criminal, and there are limits to what the purview is of both the law societies as well as the medical professions. They have a limited mandate, whereas Parliament's mandate is much larger and broader.
Okay, in terms of conscience rights for institutions, can you point me to any Supreme Court decision that guaranteed conscience rights to a publicly funded institution?
I can point you to the freedom of association under Section 2D of the Charter, which is not just a right for individuals, but it's also a collective right. And collectives form around the notion of doing what they can do collectively, what they can do individually. And
the answer is no.
In this case, well, I don't know if you want to tell me what my answer is.
Well, I'm asking you, is there a Supreme Court case that points to that? And you're dancing around the subject, but is there a Supreme Court case?
I'd refer you to the case of Mounted Police Association.
I'm sorry?
Mounted Police Association with respect to the associational rights of the collective.
So it's a union case. So you can't point to a publicly funded institution. That being said, doesn't that lead to a slippery slope that if we grant conscience rights to institutions, in this one exemption, we're opening up the Charter to issues of employment or access to a publicly funded institution for members of that particular religious group only? And how can we limit those Charter rights to your very narrow request?
With respect, sir, I think that you're blurring the issue. The issue is whether or not a group of individuals who have formed around a common creed can decide whether or not they're going to participate in MAID. That's the question. We say they can. That's the answer.